Good evening, everybody. I am Manoj Kumar Chaudhary, Advocate, Supreme Court of India. Welcome you all on the day 3 on the occasion of 106th birth anniversary of late legend Advocate Nani Palkiwala, an eminent and constitutional luminary. Today's our topic is insolvency law with in-depth analysis of CIRP and liquid process. This act came in 2016 by the name of IBC, that is Insolvency and Bankruptcy Code. The major reform in the economic condition of India was the main aim to provide by this particular code and bring the time-bound judgment frame, legal framework to give justice to the creditors who are struggling to get their money back from the borrowers. So this particular act is applicable for the company, partnership, individuals. The primary objective was the resolution for the disaster's assets and maximize the value of assets for all the stakeholders. That was the main objective for this particular code. So today we'll go in depth all the provisions and the different judicial precedents given by the Supreme Court of India. Today we have Advocate Jayaprakash Somani with us for this particular web segment. He has written more than 65 plus of books, which is available on Amazon and Flipkart, which is related to civil, criminal, competitive laws, labor laws, taxations, and he has experience of more than 30 plus as an argue counsel in different forum, from district court to high court to the Supreme Court. Over to you, sir.
Thank you. Thank you for your kind words. So friends, we'll see today what is IBC code, what are the important sections, what are the chapters. Then we will see CIRP process in detail. Then we'll see fast track insolvency process. Then we'll see pre-pack insolvency process, which is new. Then we'll see liquidation process also. So today's portion is vast. So at least I think it requires near about 1.5 hours. So I hope you will all be there. And this is a special knowledge. So as usual, we will upload this video on YouTube also, so that you can get its revision again and again when you wish. And on our app, my app, Jayaprakash Somani Supreme Court app is there, and app in the form of course also. I will upload video with study material also. So on the occasion of 106th birth anniversary of my Guru Nani Palkiwala, this corporate law Mahautsav is there, and today is third day. And today's subject is my favorite subject, because along with the advocate of Supreme Court, I'm an insolvency professional also. I'm currently handling one liquidation process. I have already completed IRP 2, then RP in one assignment. And in future, I will also work as an insolvency professional. And this is very tough examination. I cleared this examination by giving 8 unsuccessful attempts. And in 9th attempt, I cleared this examination. So this is a special knowledge. I hope you will like it. आपको सबको अच्छा लगेगा, क्योंकि एक नया कुछ है. देखते हैं. Let me start the screen. Yes. Now screen is visible to you all. NP NLC folder. Corporate Law Mahotsav. Then IBC. This is third day. IBC. Yesterday, first day, we completed Company Law and SEBI Act. Then second day, we completed RDDBFI and SURFACE Act. And today, we are going to complete Insolvency Bankruptcy Code, CIRP, Liquidation, Fast Track, and Pre-Pack Insolvency. So these are the notes. So first, I will elaborate IBC code. This is my blog on that IBC code. I have not released this blog yet, but I will release it soon. So Insolvency and Bankruptcy Code, comprehensive blog. What is the Insolvency and Bankruptcy Code 2016? The Insolvency and Bankruptcy Code 2016, Act number 31 of 2016, is a comprehensive law enacted by the Indian Parliament to provide a consolidated and modern framework for resolving insolvency and bankruptcy for corporate persons, partnership firms, and individual. A corporate person's insolvency is already notified, it is going on, but partnership firm and individual, they have not yet notified it. So when they will notify it, it will start and it will goes to DRT, Debt Recovery Tribunal. Corporate persons insolvency is going to NCLT, National Company Law Tribunal. So this is the adjudication authority for corporate person, and for partnership and individual, adjudication authority will be DRT, but it is not yet notified. So what is exactly insolvency? When any company's default is there for more than 1 crore. So creditor who is getting default, he can approach to the NCLT for CIRP process. Under section, there are so many sections, the section 7, 9 and 10 sections are there. Under 7 section, financial institute can evoke the CIRP process like bank. Then under section 9, 9 supplier, that is a supplier who is not a financial creditor, but he is an operational creditor, suppliers. He can give the legal notice first under section 8, and under section 9, he can file the application if he is not getting this money, if that amount is more than 1 CR. And third, corporate debtor himself, that company himself, itself can evoke the CIRP process. So we will see all these things, just yeah. So क्या होता है कि ज्यादा लाइबिलिटी पर जब बन जाती है, बहुत कोशिश करने के बाद भी धंधा नहीं चल रहा है, बहुत लाइबिलिटी हो जाए, तो shall that person do the suicide? No. That person have right to live dignity. So he should approach to the adjudication authority and tell that authority, this is my, I have tried hard, but my liability is more than my assets. So declare me as an insolvent. And when he gets the insolvency certificate, then he will be clear from all that debts. Whatever in ratio, creditor will get that money. They will get that money, but he will be complete out of that, and he can start his fresh. There are so many companies in our India also, and mainly in US also, who gone 3 times in insolvency, and in 4th attempt, they are in top 100 richest companies list in USA. So this is a great moment, but all the moments have the pro and cons also. So some people are taking disadvantage of this law. They are misappropriating. They are misusing this law. They are diverting their funds to personal uses, personal relatives, all, and they are declaring themselves as insolvent. So it should not happen. So law is very strict. So before this CIRP process, 2 years earlier, if any transfer is there, that will be declared as a illegal transfer of property like that. So there are complete perfect law of IBC. So let me explain you step by step. Before IBC, insolvency law in India were fragmented and scattered across multiple statutes, such as the Companies Act 2013, Sikh Industries Act 1985, RDDBFI Act 1993, SURFACI Act 2002, etc., leading to long and inefficient legislation with low recovery for creditors. The IBC integrated all aspects of insolvency law, streamlines the process timelines, and aims to maximize asset value. This is the main purpose of IBC code. Maximize asset value, promote entrepreneurship, and balance interest of all stakeholders. So liquidation is not this proper solution. Corporate insolvency resolution process is a proper solution. If we resolve that company and we take good management on that company, or we change the structure of marketing, etc., then we can revive and we can avoid the liquidation of any company. But when there is a not possibility to complete the CIRP process, and if when committee of creditors pass this resolution, we should go now in liquidation process, then liquidation happens. And this is my personal motto to give this examination. I'm not after money for this examination because I am earning good amount of money in Supreme Court practice. But this is my legal practice. But as an insolvency professional, that is my administrative job. If in my lifetime, if I am able to resolve a big company like 2000 worker, 1000 worker, and if that company faces liabilities more than their assets, and if I am able as an insolvency professional, I am able to resolve that and take good management and run that company, or I shift that company to another management, and if I can save the jobs of 2000 or 1000 workers, that will be the achievement of my degree of insolvency professional. This is my main motto behind this examination. And I have cleared that examination at the age of my 58. When people are retiring, I have given that examination 8 times. This is tough. Every time tough level is there. Examination tough level there. Negative marking system is there. So no tukka. तुक्का लगाना नहीं उसमें. तुक्का लगाते तो फेल ही होता है. So yeah, this is not the platform to explain about that examination. If you visit to IBBI website, you will get the examination details, or you can put on Google also related to the examination. Any advocate who have more than 10 years practice then can give that examination. Any chartered accountant, any company secretary who have more than 10 years practice, they can give that examination. And after that, clearing that examination, you can enroll yourself as a insolvency professional. I have cleared that examination by 64 marks out of 100 in my 9th attempt. So friends, structure, what is the structure of IBC? Code means Insolvency Bankruptcy Code. Parts, chapters, sections. The Insolvency and Bankruptcy Code 2016 is divided into 5 parts with 255 sections and 12 schedules, covering insolvency resolution, bankruptcy, regulation of insolvency professionals, and other ancillary matters. Ancillary means supporting. Overview. Part, subject matter, and sections. Part 1 is related to preliminary, sections 1 to 3. Part 2, insolvency, resolution, and liquidation for corporate person. So section 4 to 77 are very important for corporate persons, resolution, and liquidation also. Part 3, insolvency, resolution, and bankruptcy for individuals and partnership firm. Section 78 to 187. लेकिन अभी इंडिविजुअल का और पार्टनरशिप फर्म का नोटिफिकेशन नहीं हुआ है, इसलिए कानून पास होके इतने साल हुए बट दे हैव नॉट नोटिफाइड. सो अभी इसका इंसॉल्वेंसी रेजोल्यूशन प्रोसेस नहीं होता है, इसका रेगुलर सिविल कोर्ट से होता है. और जब ये नोटिफाई होगा, दैट टाइम दिस रेजोल्यूशन विल बी टेक प्लेस इन DRT, डेप्ट रिकवरी ट्रिब्यूनल. पार्ट 4, रेगुलेशन of insolvency professional agencies information utility 188 to 223, and part 5, miscellaneous, section 224 to 255. Core objective of IBC. The IBC was enacted with the following goal: consolidate fragmented insolvency laws into a single unified framework, allow time-bound insolvency resolution. This is the main feature of this code. Everything is time-bound. 14 days, 7 days, 8 days, like that. 75 days. In 180 days, CIRPC process should complete. Maximum days 330, including litigation time, etc. Like that. And for liquidation, 1 year is there. So time-bound is there. But pro and cons are there. As an insolvency professional, we are keeping that time boundness. But adjudication authority is failed to obey the timelines. So because there is a tremendous load on them on NCLT, NCALT, tremendous load is there. So they cannot resolve it in a time-bound manner. But government should frame such a type of structure, and specifically lawyers' argument timing, that time it is possible to resolve that matter in time to adjudication authority also. So balance of interest to facilitate efficient restructuring of a visible business and ordinarily liquidation of non-visible ones, non-viable ones. Facilitate efficient restructuring of viable businesses and ordinarily liquidation of non-viable ones. So when business is viable, that should not liquidate. That should be only restructure it. But when business is non-viable, that should be liquidated. Promote entrepreneurship and ease of doing business. So promotion of entrepreneurship is very vital character of this code. Balance the interest of creditors, debtors, employees, and other stakeholders. So stakeholder in any company, stakeholder are corporate debtor himself, their debtors, their creditors, their employees, and other stakeholders means suppliers, government organizations, GST department, income tax department, electricity department, All are the stakeholders in that company. Part by part highlights. I will explain you everything in detail with specific case laws also. So you will not find such type of information collectively related to IBC in practical ways, practical manner on any platform. So you are very lucky you are attending this program today lively. Those who are failed to attend this lively, they will watch this on my YouTube channel later on. But attending lively is a different inspiring part. It is a different. बालाजी के वहां पे जाके दर्शन लेना और बालाजी के खाली फोटो देख के दर्शन लेना में जो फर्क होता है ना, वो लाइव में और बाद में वीडियो देखने में फर्क होता है. So part 1 preliminary section 1 to 3 defines key concept like default, corporate person, corporate debtors, financial creditors, operational creditors, moratorium, insolvency, etc. Before reading to any new law, we should see properly its definition first. So section 1 to 3 gives preliminary, section 2 gives the definitions, establishes the scope and application of the code across India, including Jammu and Kashmir also. Part 2 is related to corporate insolvency, and liquidation. These are sections 4 to 77. This is the most widely used part of the code, covering insolvency for corporate entities. Corporate entities means companies and LLPs. LLP is also partnership, but that is a limited liability partnership that comes into corporate. So LLP's liquidation or CIRP process or company's resolution process takes place under this part. Key concepts: corporate insolvency resolution process, formal resolution mechanism for corporate debtors, committee of creditors, a body of financial creditor that steer the resolution. There are two types of creditors. One is financial creditors like bank, like that, secured creditor. And another is unsecured creditor, that is operational creditors who are supplier, like that. So when insolvency professional or IRP or RP form the COC, so in COC only financial creditors are taking part. So this is also one lacuna of this code. Operational creditors also should have their part. But when financial creditor is not there, then operational creditor COC is there. But when financial creditors are there, so operational creditors are not getting so much chance to raise their voice. They can submit their claim definitely. In timeline, they can submit the claim. Resolution professional, this is the main pillar. There are three main pillars to run insolvency. One is adjudication authority, that is NCLT. Another is IBBI, IPA, and insolvency professional. Four poles are there. So insolvency professional runs this entire show. Appointed to manage the debtor's affair during CIRP process. Moratorium. What is moratorium? Moratorium means आपको याद है, आपको आप बचपन में खेलते थे ऐसा, किसी को हाथ करते थे ऐसा, स्टैच्यू, फिर वो एक जगह पे रुक जाता जब तक आप रिलीज नहीं करते थे उसको. Like that moratorium. When CIRP process starts, there is a moratorium. Moratorium means nobody can put any case on that corporate debtor. All cases will get statute unless and until it completed. So very peacefully mind, IRP or RP, interim resolution professional or resolution professional, can run the show. But corporate debtor can file the suit. Corporate debtor can recover the money by filing suit. That is exception in moratorium. But in moratorium, others have no right to है. किसी कोर्ट में उनका केस चालू है, वो जगह पे रुक जाएगा. Like a status quo, स्टैच्यू. जैसे बचपन में स्टैच्यू को बोला ना मैंने, स्टैच्यू करने के बाद रुक जाता है वैसा. That is moratorium. Liquidation. When resolution process is not successful, then liquidation process starts. So process where assets are sold and proceeds distributed when resolution fails. Part 3. Individual and partnership insolvency. This covers section 78 to 187. As earlier I already told you, this is not yet notified, so it is not yet started, but law is there. Provide a separate process for insolvency of individual and partnership firms. Includes the procedure like fresh start, insolvency resolution, and bankruptcy. So in corporate, liquidation is their word, and in individual or partnership, bankruptcy is word there for natural persons. Applicability to individuals has been expanded gradually via notification. Part 4, regulations of professionals and information utilities. So those resolution professional, IPA, insolvency professional agencies, there are at present 3 insolvency professional agencies are there. One is of CA institution, one is of ICW institution. So these are 2 main, not 3, 2 IPAs. Yes. One is a cost accountant also. Cost accountant IPA is also there. Three IPAs are there. I'm the member of the IP of cost accountant. Cost accountant insolvencies. I'm ICAI. I'm the professional member of that organization, and then professional member of IBBI as a registered professional. I'm not soliciting, just I'm taking this, giving this information, and the purpose of this program and Nani Palikiwala's our movement is to educate the people of India, general people or advocates or corporates, to educate them. This is the purpose. With the grace of Lord Krishna, we are getting very good response in our legal practice also, in our insolvency also. So I'm not soliciting anything, just I'm sharing you my views and I'm sharing you the information to you. Regulations of professionals and information utilities, sections 188 to 223, establishes the Insolvency and Bankruptcy Board of India, IBBI, a regulator of insolvency professional agencies and information utilities. Insolvency professional handle actual resolution process. Information utilities store creditor debtors information for verification. Part 5, miscellaneous, section 224 to 255. Covers general matters like the Insolvency and Bankruptcy Fund, government power, bar of jurisdiction, appeals, override of other laws. Section 238 is very important for that. Limitation and transitional provisions. A very important subsection in section 238, which states that the provisions of IBC prevail over other inconsistent laws. So when there are 2 laws and contrary to each other, so IBC will prevail, ensuring its primacy for insolvency matters. Important sections every practitioner should know. Below are some of the most significant provisions of IBC. Corporate Insolvency Resolution Process, CIRP. Section 6, meaning of default. Section 7, application by financial creditors. Section 9, application by operational creditors. Section 10, application by corporate debtors. Section 12, time limit for completion of CIRP, that is 180 days maximum, 330 days, including litigation also. But when there is no litigation, it should be complete 180 days. But extension, we can take extension by 90 days also. That is, there is provision in this code. Section 14, moratorium, stay on claim and legal action. That is called moratorium. Moratorium statute. जगह पे रह जाओ. So stay of all claim. Any court cases, all case get it pause. Stay there. During this process, moratorium is there. Section 21, appointment of insolvency resolution professional. Section 30, submission of and approval of the resolution plan. Section 31, approval of the resolution plan by adjudication authority. Section 33, commencement of liquidation if resolution fails. Regularity and procedure. Section 60, adjudication authority for corporate debtor, that is NCLT, National Company Law Tribunal. Section 61, appeals to NCALT, that is NCLAT, National Company Law Appellate Tribunal. And Section 62, appeal to Supreme Court. But appeal to Supreme Court is only on the point of substantial question of law. Section 188 to 223, regulation of insolvency professional and utility. So procedure is also either like CPC. CPC covers some section and CPC covers some orders. So order is the procedural part, and so regulations related to insolvency professional, utility, insolvency professional agency is given in from under section 188 to 223. After this, I will show you the act also, total act also. Leading Supreme Court case laws under IBC. Since its enactment, the Supreme Court of India has delivered key judgment that shape IBC interpretation. Many other rulings are an appeal or under litigation, but several have strong precedent value. 1. Mohammed Enterprises, Tanzania Limited versus Farooq Ali Khan and others, 2025 cases there. In this case, Supreme Court reaffirmed that IBC is a complete and self-contained code. It emphasized that High Courts should be very cautious in exercising writ jurisdiction under Article 226, where IBC provides specific statutory remedies and appellate mechanism. So 226 and 227, which are the writ jurisdiction of High Court, is not freely open in IBC matters. When in rare case, when there is a fundamental right, when infringement, that I can approach because they have that power under Article 226, that is the power of High Court. But when specific statutory remedies are available under this code, so High Court should not entertain these petitions. So this is the outcome of this Mohammed Enterprises Tanzania Limited. Second important case law is SR Steel India Limited versus Satish Kumar Gupta and others, 2019. A landmark decision clarifies the power of Committee of Creditors, COC. So when we form the Company of Creditors, so Company of Creditor is important decision making. They have the decision maker power, making power to COC. And insolvency professional is executor. His right is to execution, but he have to take the meetings of COC, take that approval, and then implement it like that. Supreme Court held that while the COC exercise commercial judgment, the adjudication authority, NCLT and CLAT, can examine if the resolution plan violates law or public policy. This balance commercial freedom with regularity oversight. Very nice judgment. Then constitutional validity of professional of a person guarantor provisions 2023. Supreme Court upheld the constitutional validity of IBC provisions related to the insolvency of personal guarantors, section 95 to 100. It clarifies that natural justice principles are satisfied and that adjudication authorities' decisions must observe fair hearing norms. Then SC clarifies on moratorium and civil criminal proceedings in 2025. Supreme Court held in Rakesh Banot versus Gurudas Agro Private Limited that the moratorium under the IBC section 96 is limited to civil debt recovery claims and does not stay criminal proceeding, that is section 138 NI Act, check bounce, etc. Then 5. Supremacy and overriding of other laws. Supreme Court rulings in case like Sudarshan Bhatt versus CBIC have held that IBC moratorium and its provisions override inconsistent recovery procedures under other statute like Customs Act once CIRP is in force. Then why IBC matters in India? So time-bound insolvency resolution improves creditor recovery and reduces litigation delays. Unified law replaces fragmented legacy statute, reducing confusion and enhancing predictability. Role of professionals and regulators, IBBI, ensures structured, transparent resolution process. Supreme Court interpretations refine legal principles and offer clarity on critical aspects like moratorium, jurisdiction, admissibility of appeals, and exercise of commercial judgment by COC. And conclusion, the Insolvency and Bankruptcy Code 2016 is a transformative law that redefined corporate and personal insolvency law in India. It introduced a uniform, time-bound, and creditor-driven resolution framework. Creditor-driven. Decision maker is a creditor. Here, this is the main theme of this IBC code. While instituting transparent procedures and regulatory oversights. Through key Supreme Court rulings, the code's provisions have been clarified and strengthened, creating a jurisprudence and balances creditors' right, debtors' protection, and commercial realities. So this is the Insolvency Bankruptcy Code. Now I will show you that law first. This is the Bare Act. You will get all this study material on my app in the form of course. Yes. Why it is not opening? I will try again. It is now loading. See, Insolvency Bankruptcy Code. This is last update 1/6/2020. arrangement of sections. So these are the part 1 preliminary, part 2 insolvency resolution liquidation for corporate debtors, then chapters, then chapter liquidation process, fast track corporate insolvency, voluntary liquidation of corporate person, adjudication authority for corporate person, offenses and penalties, insolvency resolution and bankruptcy for individual and partnership firms. So all these sections, while in practice in Supreme Court, I am regularly handling these matters. And lastly, it have the 11 schedules and detailed law is there. So this is for your homework. Read that law. If you don't have the knowledge of corporate, you don't have knowledge of finance like that. So initially you will feel it is very tough law. But when you are used to it, then you will feel it is very, very interesting law. Now I will show you fast track CIRP process. This is a fast track. This is my blog on this fast track CIRP under IBC. I have not yet released that blog, but I will release it soon. The introduction to fast track CIRP. What is the fast track? Regular CIRP process should be completed within 180 days, maximum 330 days. But for MSMEs and startups, what happens in startups? People are starting the business, but if it goes in on wrong direction, so they should be get relief from that as early as possible. So fast track CIRP process should be completed within 90 days. Extension can take there for 45 days, but law is there. So the fast track corporate insolvency resolution process, that is fast track CIRP, is a speedier insolvency resolution mechanism introduced under the IBC to deal with small, less complex corporate debtors, preliminary, MSME, and startups, where prolonged insolvency proceedings would destroy value rather than preserve it. The objective is to resolve insolvency quickly, reduce procedural cost, preserve enterprise value, and improve ease of doing business for small entities. Fast track CIRP is governed by Section 55 to 58 of the IBC and corresponding IBBI regulations. Statutory framework governing provisions, IBC Section 55, 56, 57, and 58. Applicable CIRP sections, mutatis mutandis, 6 to 32A. Procedure is same, but it is fast track procedure. Procedure is same, 6 to 32A. So mutatis mutandis means डिटो ऐसा जैसा कि वो ऊपर हम लिखते हैं ना 1000 और नीचे भी हमको 1000 नहीं लिखना था, हम क्या करते हैं 1000 नहीं लिखते, डिटो करते हैं. So that ditto is called mutatis mutandis. That is Latin word. जैसे मराठी में, हिंदी में संस्कृत वर्ड आते हैं ना, तो वैसे इसमें इंग्लिश में लैटिन वर्ड्स आते हैं. लॉ में स्पेसिफिकली लैटिन वर्ड्स ज्यादा आते हैं. So regulations IBBI fast track insolvency resolution process for corporate persons regulation. Regulation means rules. 2017. Adjudication Authority NCLT and Appellate Authority NCLAT and Supreme Court. Applicability and eligibility. Section 55. Fast track CIRP is available to the following categories of corporate persons as notified by the central government. Eligible entities, small companies as per the Companies Act 2013, startups as per DPIIT notifications, unlisted companies with assets less or equal to 1 crore, and such other criteria as may be notified. Rational, these entities usually have limited creditors, simple debt structures, and low asset base. Initiation of fast track CIRP. Who can initiate? Section 55 read with section 6. So same as a normal CIRP will be initiated by financial creditor under section 7, operational creditor under section 9, and corporate debtors under section 10. Important. The applicant must specifically pray for fast track CIRP and demonstrate eligibility under section 55. 5. Commencement and admissions. Once the NCLT is satisfied that default has occurred and corporate debtor is eligible for fast track process. Yes, I will complete this and then I will elaborate you another process also. It admits the application and declares commencement of fast track CIRP. Consequences of admissions. Moratorium under section 40 applies. Interim resolution professional IRP appointed. Public announcement issues. Time limit key distinction section 56 statutory timeline. Process fast track CIRP 90 days. One time extension 45 days. Maximum period 335 days. Contradict with normal CIRP. Normal CIRP is 180 plus 90, maximum 330 days. Fast track CIRP strictly capped by 135 days. Purpose, speed, and cost efficiency. Role of IRP and RP in fast track CIRP. Appointment, IRP appointed at admission. COC may confirm or replace IRP as RP. जब भी आरपी अपॉइंट होता है ना, आईआरपी अपॉइंट होता है, तो विद इन 1 month CIR in this case little earlier COC formed, and first meeting of COC decide whether to carry on this insolvency professional as a RP or they can change it. Duties of this IRP or RP: manage affair of corporate debtors, collect and verify claims, constitute company committee of creditors, invite resolution plan, ensure compliance and compressed timelines. Committee of creditors. Composed of financial creditors only, section 21 applies. Voting share proportional to debt. Operational creditors may attend meetings without voting right. Operational creditor can attend meeting, but they don't have the voting right. Voting right is with only financial creditors. Commercial wisdom of COC remain supreme, even in fast track CIRP also. Relevant principles: Swiss Ribbon Private Limited versus Union of India in 2019 for SEC 17. Supreme Court affirmed that the creditor-driven insolvency is the backbone of IBC. Resolution plan in the fast track CIRP. Eligibility section 29A. Resolution plan. 29A is very important. All disqualifications apply. Willful defaulters, promoter of NPAs, and persons convicted of specific offenses. These three category people cannot take the part in as a RA, resolution applicant, under section 29A. Key case laws. ArcelorMittal India Limited, Private Limited versus Satish Kumar Gupta, 2019 to SEC 1. Section 29A applies strictly to all resolution process, including fast track. Requirement section 32. Resolution plan must provide for insolvency cost, protect operational creditor, be legally comply, be feasible and viable. Already I have told you this is a little bit tough subject for new people, but again and again and again, when you watch this, you hear this, then you will get used to it. When any lawyer can do that matter, then why you should not do? When any lawyer can become insolvency professional after 10 years practice, why you should not? So take this in your mind. And if you are interested, you can evoke for legal practice also, and you can come in administrative side also as a resolution professional. 10. Approval of resolution plan. Resolution plan approved by COC with 60C voting share. Submitted to NCLT. NCLT ensures compliance, not commercial merits. NCLT commercial merit नहीं देखेगी, खाली compliance देखेगी. Because COC's wisdom is there. Landmark case, Committee of Creditors of Esser Steel versus Satish Kumar Gupta 2019, 16 SCC 479. Courts cannot interfere with commercial wisdom of COC. Failure of Fast Track CIRP, Section 58. Fast Track CIRP fails if no resolution plan is received within 90 or oblique 135 days. COC rejects all plans. Approved plan violates law. ये तीन में से कुछ भी एक होता है. First, no resolution plan is received. COC reject all plans. Approved plan violate law. If any one from these three happens, liquidation proceeding commence automatically under section 33. Fast track CIRP versus normal CIRP. So target entities in fast track, MSME, startup. And in normal CIRP, all corporates. Timeline 90 plus 45 days. In normal CIRP, 180 plus 90 days. Complexity, this is a low, this is a medium high. Cost lower, higher. Object, fast track, speedy, and all corporate resolution plus revival. Judicial approach and case laws. While Supreme Court has not laid down many separate rulings exclusively on fast track CIRP, its general IBC jurisprudence applies equally, including Innovative Industries Limited versus ICICI Bank 2018. Once a default is proved, admission is mandatory. Swiss Ribbons case, resolution prepared over liquidation. Speed is fundamental to IBC. Esser Steel case, COC's commercial wisdom is non-justificable. These principles are even more strictly enforced in fast track CIRP due to compressed timelines. 14. Practical challenges in fast track CIRP. Difficulty in completing process within 90 days. These are the practical difficulties before the insolvency professional and before COC also. Delay in the claim verification, limited pool of resolution applicants, operational creditors often dominate debt structure. Courts have caution against misuse but support fast track objectives. Important practical tips. Eligibility must be clearly pleaded at filing stage. Pre-packed settlements improves success. Promoters of MSME may benefit from relaxed Section 29A norms, Section 240A. So MSME promoters are exceptions in these 298 norms. They can take the part as a resolution applicant. Fast track CIRP is ideal for early stage insolvency, not deeply stressed companies. What is the conclusion of this? Fast track CIRP under the IBC 2016 is a specialized, expedited insolvency mechanism designed for small and emerging businesses, while procedural framework mirrors normal CIRP. Its compressed timeline, limited scope, and emphasis on speed make it a powerful tool for early resolution. Supreme Court jurisprudence consistently reinforces that the time-bound resolution and creditor control are the heart of IBC, principles that apply whenever greater force to fast-track CIRP. So I first complete fast track, then I will give you the brief information but comprehensive information related to regular CIRP process. So I have write blog on also that regular CIRP process. So Corporate Insolvency Resolution Process, CIRP. This is for all companies, LLPs, not only for MSME or startups. This is for all. And limitation is 180 days. Within 180 days, maximum 330 days, it should complete it, including litigation time also. Corporate Insolvency Resolution Process is the core mechanism under the Insolvency Bankruptcy Code 2016 for resolving insolvency of corporate persons, companies, LLPs. It is a creditor-driven, time-bound process aimed at resolution of financially distressed but viable companies, maximization of the value of asset, promotion of entrepreneurship, balancing interest of all stakeholders, ensuring certainty and speed in insolvency proceedings. CIRP is governed primarily by Section 6 to 32A of IBC and relevant IBBI regulations 2016. Statutory framework of CIRP, relevant provisions, Section 6 to 32A, 60 to 62, and 238. Regulations, IBBI CIRP Regulation 2016. Adjudication Authority, National Company Law National Company Law Tribunal, NCLT. And Appellate Authority is NCLAT, NCLAT, and Supreme Court. Who can initiate CIRP? It is given in Section 6. Who can initiate CIRP? CIRP may be initiated upon occurrence of default by. When default is there above 1 crore, that time financial creditors can evoke CIRP process. They can initiate. They can file the application under Section 7. Operational creditors under Section 9. And corporate debtors self-initiation, Section 10. Default means non-payment of debt when due. Section 3 subsection 12. Initiation of CIRP detailed process. CIRP by financial creditors, Section 7. Filed, this application should be filed before NCLT. No requirement of prior demand notice. For financial creditors, no requirement of prior demand notice. Proof of default via loan agreements, bank records, information, utility records. Key case laws, Innovative Industries Limited versus ICCI Bank 2018-1 SCC 407. Supreme Court held Once a default is proved, NCLT must admit the application. NCLT cannot examine dispute on merit. CIRP by operational creditor, Section 9. Mandatory demand notice should be given under Section 8. So when default is there by operational creditors for more than 100 for more than 1 crore rupees. So before filing the application under Section 9, that operational creditor should give the first demand notice under Section 8 and 10 days to respond. Only 10 days gap is there to get response. If it is not, you are not getting any response from the corporate that corporate debtor, that time application fails. If then application file, but application fail if pre-existent dispute exits. If pre-existent dispute exit, application fail. Debt is not operational. If debt is not operational, it is also fail. Key case law for this Mobilox Innovations Private Limited versus Curusa Software 2018 1 SCC 353. Supreme Court clarifies dispute need not be proved conclusively. A plausible contention is sufficient to reject Section 9 application. CIRP by corporate debtor, Section 10. Voluntary insolvency subject to eligibility conditions. No permitted if liquidation already commenced. Section part 5 of this my block, admission of CIRP and consequences. Upon satisfaction, NCLT admit the application under sections 7, 5, 9, 5 and 10 to 4. Consequences of admission, commencement of CIRP. Once admission matter admitted, from that day, commencement of CIRP starts. Then declaration of moratorium under section 14. So all matters in any court against that corporate debtor will get pause, stays there to run that matter. That is moratorium. Appointment of interim resolution profession, IRP, public announcement. Moratorium section 14. Moratorium prohibits institution and continuation of suits, execution of judgment, transfer or alienation of assets, recovery action. For all these here, there is moratorium. Essential services continue, but these are exception. Essential services can be continued. Does not bar criminal proceedings. Criminal proceedings are not barred under moratorium. Key case laws. P. Mohan Raj versus Shah Brothers 2021 6 SCC 258. Section 138 NI Act proceedings are stayed during moratorium. Interim Resolution Professional IRP section 16 to 20. Appointment within 14 days of admission. Initially for 30 days. What is the power and duties of insolvency professional? Take control of management, collect claim, preserve assets, constitute committee of creditors. Then committee of creditors, COC, section 21. Comprises the financial creditors only. Operational creditors attend meeting but no voting rights. Voting share proportional to debt. I will explain you this. Voting share, how it is proportional to debt. Suppose there are 3 financial creditors, Bank A, Bank B and Bank C. Bank A have the loan of 10 crores. Bank B have the loan of 5 crores and Bank C have the loan of 3 crores. So voting right will be in the ratio of 10 as to 5 as to 3, like that. So that is voting right. They have the voting right in proportion. Commercial declaration decisions lie exclusively with COC. So COC's approval everywhere you need while you are running a CIRPC process as an insolvency professional. Key case laws: Swiss Ribbon Private Limited versus Union of India, 2019 for SEC 17. Upheld constitutionality of IBC, recognized supremacy of COC's commercial wisdom. I'm getting tired now. Resolution Professional, RP, Section 22. Appointment by COC, replace IRP, conduct entire CIRP. Entire CIRP, RP is continuing. Submission and evaluation of resolution plan, eligibility section 29A, disqualified willful defaulter, promoters and NPA companies, related parties. Key case laws: ArcelorMittal Mittal India versus Satish Kumar Gupta, 2019 to SEC 1. Section 29 is strictly enforced to prevent backdoor entry of defaulters. Contentions of resolution plan, Section 32. Plan must pay insolvency cost, protect operational creditors, comply with law, be feasible and viable. Approval of resolution plan, Section 32 and 31. COC's approval by 66 voting share. NCLT ensures legal compliance. Once approved, plan is binding on all stakeholders. Landmark case, Committee of Creditors of SR Steel versus Satish Kumar Gupta, 2019, 16 SCC 479. Supreme Court held that NCLT and NCALT cannot interfere with commercial decision of COC. Distribution of proceeds in COC's prerogative. I should take the break. But after completing this, I will take the break of 5 minutes. You also take the break of 5 minutes. And then we have to complete 2 more presentations. That will require 15 minutes only. But that is, one is liquidation and one is the pre-pack insolvency, which is very new. Pre-pack insolvency process. That is out of court settlement. You can say that, pre-pack. So before, but that is also with the section of this code. Time limit under CIRP, section 12 is there. Normal CIRP 180 days, extension 90 days. Absolute outer limit 330 days. So when you do the sum of 180 days, 90 days, it is not 330 days. So 330 days is not the total of this. 330 days means including this 180 plus 90 plus litigation time. Maximum period is 330 days. Mandatory timeline. And if it is not completed in 330 days, then it will go automatically in liquidation. Then. Case law, commercial creditors of SR Steel, the limit are mandatory, not directory. Part 3, failure of CIRP, liquidation, section 33. When CIRP fail, no resolution plan, COC rejects plans, plan violates law, company goes into liquidation. CIRP versus liquidation. What is the key difference? So, objective, revival, and winding up. In CIRP, revival of that company and liquidation, winding up that company. Control in CIRP, RP is controlling that. And in liquidation, liquidator is. So these are the name for that particular part. When you are initially appointed as an insolvency professional, you will be called as IRP. After first COC meeting, when you confirm as RP, or if COC change that RP, so that RP will carry on that remaining part process. So he is called RP. And when liquidation process started, same RP can be called as a liquidator, or COC can change also liquidator. Outcome resolution plan and asset sale. In CRP, resolution plan is there and asset sale, a distribution of that assets amount between the different creditors that per as per the waterfall mechanism, haircut waterfall mechanism. Appeals and jurisdictions, NCLT section 61 and Supreme Court section 62. Appeal only on question of law before Supreme Court. Overriding effect, section 238. IBC override all inconsistent laws. SURFACI and RDDBFI Companies Act held to IBC. Case law for this particular part. Sundaresh Bhatt versus CBIC 2022. IBC prevails over Custom Act once CIRP begins. Recent important Supreme Court principles. IBC is a complete code. Speed and clarity, speed and certainty are paramount. Judicial interference is a minimal. COC's commercial wisdom is supreme. Resolution preferred over liquidation. Conclusion. The CIRP framework under IBC 2016 represents a paradigm shift in Indian insolvency law with strict timelines, creditor control, professional management, and judicial restraint. CIRP ensures efficient resolution of corporate distress while safeguarding legal and constitutional principles through Supreme Court jurisprudence. Friends, I will take here a break of 5 minutes. So I am pausing the recording. Yes. Yes. So let me share you all screen liquidation process. This is liquidation process. This is my block on liquidation process. So when CIRP process is not successful, that time automatically that company goes in liquidation. So liquidation under Insolvency and Bankruptcy Code 2016 is the last resort when revival of corporate debtor is not feasible. The objective of liquidation is ordinarily winding up of the corporate debtor, maximization of value of assets, fair and equitable distribution to stakeholders, ensuring transparency and time-bound process. Unlike the Companies Act regime, liquidator under IBC is creditor-driven, professional managed, and time-bound. This is the main difference between winding up by High Court and under Company Act and in under liquidation under IBC. This is the main difference. Liquidation under IBC is creditor-driven, professional managed and time-bound. Statutory framework, governing provisions, section 33 to 34, part 3, chapter 3 of IBC. Regulations, IBBI, Liquidation Process Regulation 2016. Adjudication Authority, Company, National Company Law Tribunal, NCLT. When does liquidation commence? Section 33 is related to that. Liquidation of corporate person may be ordered by NCLT in the following circumstances. A. Failure of CIRP. Liquidation is ordered if no resolution plan is received within the CIRP period. Resolution plan is rejected by NCLT or COC resolved to liquidate by 66% voting share. B. Contravention of resolution plan. If an approved resolution plan is violated, liquidation may be initiated. Key case law K. Shashidhar versus Indian Overseas Bank 2019-12 SCC 150. Supreme Court held that commercial decision of COC to liquidate is not justicable unless it violates the law. Consequences of liquidation order, Section 33. Once liquidation is ordered, CIRP comes to an end. Resolution professional become liquidator under Section 34. Moratorium under Section 14 ceases. So, moratorium under 14 ceases, but fresh liquidation moratorium under Section 33(5) begins. Power of Board of Directors ceases. Appointment of liquidator, Section 34. Resolution professional generally continues as a liquidator. NCLT may replace him for cause. Liquidator must be an IBBI registered insolvency professional. Powers and duties of liquidator, Section 35. The liquidator has extensively statutory power, including take custody and control of assets, evaluate and sell assets by auction or private sale, defend or institute legal proceedings, carry on businesses for beneficial liquidation, verify, admit and reject claims, distribute proceeds as per the Section 53. That is waterfall mechanism. Prepare reports and accounts. Liquidator act as a fiduciary of all stakeholders. These are the duties of liquidator. Liquidation assets, Section 36. What form part of liquidation assets? Estate. Asset में estate. Liquidation estate. All assets owned by corporate debtors, assets recovered under avoidance proceedings, intangible assets, actionable claims, exclusion, assets held in trust, personal assets of shareholders, claim process, Section 38 to 42, submission of claims, creditor must submit claim within a prescribed time. Claims may be financial, operational, secured or unsecured. Verification, liquidator verifies claims, admit or reject claim with reasons. Appeal lies in NCLT under Section 42. This is very honorable job as a liquidator. I am already running one company in liquidation as a liquidator, but it's a very honorable job, very nice job, but very sensitive job, very responsible job also. Secured creditor in liquidation, Section 52. Secured creditor have two options. One, relinquish security to liquidation estate paid as per the Section 53 waterfall. Release security outside liquidation. Surplus, if any, goes to estate. Key case, Indian Overseas Bank versus Ashok Saw Mills 2009. Principal reaffirmed under IBC. Secured creditors' rights preserved but subject to IBC framework. 10. Distribution of assets waterfall mechanism, Section 53. Section 53 provides a statutory priority. So all participant kindly focus on that. When liquidation done and assets are liquidated by RP, so that proceedings of that assets in which waterfall mechanism distributed first. So first it will distribute to insolvency resolution and liquidation cost. Then second, secured creditor who relinquish security. Relinquish means to leave it, to leave the authority. And workman dues for 24 months. They have second priority. First priority, insolvency resolution or liquidation cost. Second, secured creditor or workman dues. Third, employees dues for 12 months. So workman dues have the first priority and employee do have a third priority. So what is the difference between workman and employee? So workman is a labor class and employee are sophisticated class. So they have a third level in water mechanism, but workmen have the second level. Unsecured financial creditors have the fourth level. Fifth, government dues, 2 years remaining secured creditors. Others, debts and dues, preferential shareholders, equity shareholder, partner. This is the waterfall mechanism. Landmark case for that, Committee of Creditors of SR Steel versus Satish Kumar Gupta, 2019, 16 SSC 479. Supreme Court upheld statutory primacy of Section 53 waterfall. Avoidance transaction, Section 43 to 51 is very important. The liquidator can avoid certain transaction undertaken prior to insolvency. Preferential transaction, Section 43, undervalued transaction, Section 45, and extortionate credit transaction, Section 50, and fraudulent transaction, Section 66. Under any of these transactions, if any property transferred like that in that particular period, for example, in last 2 years, if any property transfer, that will come into preferential transaction, undervalued transaction, that is different. Extortionate credit transaction, fraudulent transaction. So purpose to prevent assets stripping and protect creditors. Case laws related to this, Anuj Jain versus Axis Bank 2020, 8 SEC 401. SC clarifies scope of preferential transaction and look back period. Dissolution of corporate debtors, Section 54. After completion of liquidation, liquidator submits final reports. NCLT orders dissolution and corporate person ceases to exist. एंड हो जाता है, मर जाता है कॉर्पोरेट पर्सन, कंपनी खत्म हो जाती है. Timeline in liquidation stage, completion of liquidation 1 year. Fast track liquidation for MSME, reduced timelines. Delays are discouraged. IBC emphasize speeds. Judicial principles from Supreme Court, Swiss Ribbon Private Limited versus Union of India 2019. Liquidation is a last resort. Resolution preferred over liquidation. K. Sashidhar case, COC's commercial wisdom includes liquidation decision. Sundaresh Bhatt versus CBIC 2022, IBC override recovery proceedings under other statute. Anuj Jain case, strict interpretation of avoidance provisions. Section part 15 of my block is IBC liquidation versus Companies Act winding up. Aspect IBC Companies Act. Control in IBC creditors, Companies Act court. Timeline and IBC fixed, Companies Act lengthy. Priority in IBC statutory, Section 53, and in Companies Act discretionary. Objective value maximization, and in Companies Act formal winding up. Key takeaway. What is the key takeaways? Liquidation is structural, transparent, and credit-centric. Liquidator plays a vital fiduciary role. Section 53, waterfall is mandatory. Judicial interference is minimal. Supreme Court jurisprudence strongly support IBC objectives. My concluding remark, liquidation under IBC 2016 represent a paradigm shift from transactional winding up laws. It ensures predictability, fairness, and speed, while preserving creditors' rights and market disciplines. Supreme Court decisions having consistently reinforced that IBC is a complete code and liquidation must strictly adhere to statutory priorities and timelines. And last but not least of today's this program is a pre-pack insolvency resolution process. This is just a new which come recently. Pre-pack insolvency resolution process, PPIRP, Pre-pack insolvency resolution process under IPC. The Pre-Pack Insolvency Resolution Process was introduced in India by the Insolvency Bankruptcy Code Amendment Ordinance 2021, later enacted as a law to provide a hybrid insolvency framework combining out-of-court restructuring and in-court approval. So out of court you restructure and in court get it approval. So pre-pack mechanism aims to enable speedy resolution, reduce insolvency cost, preserve business continuity, provide flexibility to MSMEs, minimize value erosion. PPIRP is primarily designed for micro, small, and medium enterprise. Statutory framework. Note down this point. Pre-pack insolvency resolution process is designed for micro, small, and medium enterprises. That is MSME. Statutory framework governing provisions, IBC section 54A to 54P, chapter 3A and part 2. Regulation IBBI Pre-Packed Insolvency Resolution Process Regulation 2021. Adjudicating authority is obviously NCLT. Applicability and eligibility, section 54A. PPIRP is applicable only to MSAP corporate debtors. Eligibility conditions. Corporate debtor must be an MSME. Default amount should be 10 lakh to 1 crore as notified. Corporate debtors must not be undergone in CIRP or liquidation process. No PPIRP or CIRP completed in a proceedings 3 years. Not classified as a willful defaulter. K feature, only a corporate debtor can initiate PPIRP. Creditor cannot force it. This is very important. In regular CIRP or in fast track CIRP, financial creditors, operational creditors, and corporate debtor, these three can initiate. But in pre-pack insolvency resolution process, only corporate debtor himself that can initiate. No creditors cannot force it. Pre-initiation requirement. Before initiating this, what are the requirements? Section 54A to 54C. Before filing application with NCLT, the corporate debtor must obtain approval of 66% unrelated financial creditors, declaration of default, special resolution of shareholders 75%, name of proposed resolution professional RP. This ensured creditor consent before court involvement. Initiation of PPIRP Section 54C. Application filed before NCLT. NCLT must admit or reject within 14 days on admission. On admission. On admission, PPIRP commences. Moratorium under Section 14 modified applies. RP appointed. Control of management, debtors in possession model. Unique feature of PPIRP. Unlike CIRP, management remain with the promoters. So this is the difference. In regular CIRP, management goes to the RP, resolution professional. But in PPIRP, management remain with the promoters. Corporate debtor continues business operations. RP supervise and monitors only. Creditor retain control through COC. Exception, Section 54J. If fraud or gross mismanagement is detected, NCLT may transfer control to RP, convert PPIRP into full CIRP. Role and power of resolution professional, Section 54F to 54H. Resolution professional duties include conduct PPIRP, monitor management, confirm compliance with law, invite resolution plan if required, convene COC meetings, submit reports to NCLT. RP does not displace management unless ordered by NCLT. Committee of creditors constituted by RP comprises financial creditors only, voting threshold 66%. Commercial wisdom of COC remain paramount. Judicial principle, general IBC law, Swiss Ribbon Private Limited versus Union of India 2019. Creditor-driven process is the backbone of IBC. Base resolution plan, Section 54K. Key feature, the corporate debtor submits a base resolution plan, must comply with Section 32, must provide for payment to operational creditors, evaluated first by COC. 10. Swiss challenge mechanism, Section 54K. In the base resolution plan, impair claims of operational creditors or is rejected by COC. RP invites competing resolution plan. Swiss challenges, promoters plan completes and third party plans. Best plan chosen by COC. Promoter gets right to improve plan. Ensured value maximization and transparency. Approval of resolution plan, Section 54L. COC approves by 66% voting share. Submitted to NCLT. NCLT checks legal compliance, fair treatment to stakeholders. Once approved, plan is binding on all stakeholders. Time limit in PIRP, Section 54D. Stage. Completion of PPIRP 120 days. COC approval of plan 90 days. Absolute outer limit 120 days. Faster than CIRP 330 days. Failure of PPIRP Section 54O. PPIRP fails if no approved resolution plan, fraud or gross mismanagement, COC resolved to terminate. NCLT may terminate PPIRP or convert that PPIRP into regular CIRP. 14 avoidance transaction, section 54J, read with section 43 to 51. Preferential, undervalued, extortionate, and fraudulent. RP can initiate avoidance proceedings during PPIRP. In my liquidation case, we have conduct the forensic audit of the accounts, and we found so many frauds of the corporate debtors. And then we find the FUFE application. FUFE application means this preferential, undervalued, extortionate, fraudulent transactions application that admitted in NCLT. Key case principle, Anuj Jain versus Axis Bank 2020, strict scrutiny of preferential transaction. PPIRP versus CIRP, key difference. Applicability, MSME, all companies. Initiation, corporate debtors only, creditors, debtors. Control, debtors in possession, creditors in control. Timeline, 120 days, 330 days. Cost lower, cost higher. Flexibility, high and moderate. Judicial approach, case laws, already we have discussed it in earlier. Practical advantage, PPIRP, minimize business disruption, lower insolvency stigma, faster resolution, promoter participation allowed, suitable for MSME distress. Challenges and limitations, limited to MSMEs, risk of promoter abuse, hence safeguards, required creditors concessions upfront, still evolving jurisprudence. And my concluding remark, the pre-pack insolvency resolution process marks a significant evolution in Indian insolvency law, offering a balanced, efficient, and flexible framework for MSME by combining out-of-court negotiation with judicial oversight. PPIRP ensures speedy, valuable preservation, and creditors' confidence while remaining aligned with core IBC principles of transparency and fairness. Okay, so this is the end of today's presentation. Let me stop the screen. It is a very complicated subject. Now you know there are so many laws for this examination, so many procedures are there. So it is very easy to crack this examination for chartered accountants because they are chartered accountant, company secretary, because they are regularly handling that matter. But it is very hard for advocate because advocate is handling criminal matters, civil matters, property matters. Very few advocates are handling corporate matters. So many advocates are trying examination and they left that examination without getting any success. But very few advocates can get success to clear that examination. But for monetary benefit, if you think so, advocacy is better than insolvency professional in monetary terms. I'm not satisfied in monetary terms as a resolution professional. And there is time bound by NCLT, time bound management. So you have to do that work with the help of IPE. I'm the director of IPE, Decode IP of Bombay. So they are helping me to take this COC meeting, all that. And compliances are so much compliances. And after getting insolvency professional position, then you have to do at least 15,000 yearly expenses to intact your license of insolvency professional. It did not happen in our legal practice. In legal practice, once you get this sanad, certificate of registration from the Bar Council, then you did not to renew every year. But in insolvency, we have to take AFA every year by paying handsome money to it. And in liquidation process or in CRP process, whatever fees we are earning, out of that we have to pay to IBBI some nominal, but some part of fees we have to pay to IBBI. It is not happened in our advocacy. After getting sanad, we don't need to pay any part of fees, our advocacy fees, to Bar Council, State Bar Council or Bar Council of India. We don't need that. May in future, after seeing this mechanism of the IP, Bar Council can get this amendment also, and they can. But lawyers are very clever. They know how to hide the fees from the Bar Council like that. If it is applicable in future, at present it is not applicable to. So if you are interested in earning money, I will not advise you to become a resolution professional. You focus on your advocacy. You can earn much better that amount than insolvency professional. But if you are a madman like me, to get created some good knowledge, to getting knowledge, to getting challenges, to getting challenges in administration. When we are going and take the possession of that assets of that corporate debtors, that time many times fightings are there, many times quarrels are there. We have to take the support of the police, and police is bound to give the support to the insolvency professional while he is taking the possession of that company. So many problems we have to face, but I like challenges. Always I like challenges. I like complicated cases. I don't like routine cases. I like complicated. Right? I more like property matters than criminal matters than civil matters, because civil matters, criminal matters, service matters are much easier than property matter. But I like property matters more, not for the purpose of money, for the purpose of the exercise of mind, like our health exercise. We are doing exercise regularly, yoga, running. I'm doing my regular exercise, walking, okay, everything I'm doing. But for mental also, you should have the habit of exercise, and your mental power will increase when you are taking number of good challenges for your life in your profession. So two things will happen. One, your mental exercise will be done, and second, you will get more exposure. अरे यार ये सोमानी एडवोकेट अच्छा है, ही इंसॉल्वेंसी प्रोफेशनल भी है, एडवोकेट भी है, कॉर्पोरेट मैटर भी हैंडल करता है, ये अच्छा लॉयर है. बट टू गेट दैट रिकग्निशन, we have to strive hard. Our endeavor to get that position is very much difficult. Not impossible. Nothing is impossible in life. So this is the corporate law Mahotsav. Every year we will take the corporate law Mahotsav on the occasion of my Guru's birth anniversary, on before 16th January. 16th January is their birth anniversary. If you are in Delhi, definitely you come for dinner. I have arranged dinner here, prasadam. भंडारा रखा है मैंने यहाँ पे, सामने लगेगा हमारे ऑफिस के सामने, न्यू अशोक पे. दिल्ली में तो आइए, और दिल्ली के नजदीक आजू बाजू भी किधर है तो भी जाइए. हम आपके ग्रुप पे डालेंगे भंडारा का इन्विटेशन. जरूर आइए, भंडारा खाइए. और हमारे जो गुरु जी है, बस गुरु जी का क्या करना है, हमको एक स्मरण करना है, अच्छा श्रद्धांजलि उनको अच्छे देना है. और फ्यूचर में हमारा प्लान है, उनको पद्मश्री पद्म भूषण तो मिला था, लेकिन उनको भारत रत्न मिलना चाहिए. इसलिए आई वांट टू टेक द स्पेशल मोमेंट थ्रू नानी पालकीवाला नेशनल लॉ क्लब. We will take the special moment, and now this special moment is we are increasing our life member, and our life membership is only in 500 rupees for 20 years. So many such type of good lectures, good programs you will able to attend free of cost. And in many professional programs, you will get 50% discount also, up to 50% discount, 10, 20, 50% discount that courses if you are the life member of Nani Palikwala National Law Club. So if you are not life member, you take the membership of life member. On the post of this program, there is a number of Advocate Manoj Kumar Chaudhary. He is the national convener of Nani Palikwala National Law Club. Shruti Kriti, Advocate Shruti Kriti is a national secretary of Nani Palikwala National Law Club. And I myself is a Pradhan Sevak of this Nani Palikwala National Law Club. चलो बहुत देर हुआ ठीक है थैंक यू वेरी मच sorry Manoj kindly conclude officially just yes now you can unmute yourself Manoj.
Thank you viewers for attending such a late, and thank you very much, sir. The takeaways for today's class is for the insolvency that this particular is a time-bound litigation. So this legislation is a time bound of 180 days, and beyond that, maximum with the legal challenges, you can go up to the 330 days. We have got the intense idea about the PPIRP, which is a new concept, totally came after the 2016 with the amendments. Thank you very much, sir. Not taking much time. Okay, already we are late.
Yes.
Thank you very much, sir. Thank you.
Thank you.
Thank you.